Hey, everybody. Hope you're all well. Pardon me. Um, yeah, I'm not in my usual spot, right? I'm out by Harrisburg, so. And I was actually going to be in a different room, but the chair in here is more comfortable. That's a closet behind you. I can't close the door because there's boxes down below, so it's a lot of the stuff we moved up from um, Jason's parents' house when like you can see up there, there's all sorts of like model things. There used to be a lot of Hess trucks. Not sure exactly what those are, but just stuff, the person collected and you don't know what to do with it. But I think we're on. So I'm going to get the comments, hopefully. Hi, Mike Page. You guys can hear me fine? Yeah, thank you, Dimple. Okay. So I hope everyone had a great week. Has it been good? Everyone feeling okay? Everything here is copacetic. Let's see. We'll just hop in everything. I see Justin Zane is here. Good to see you, Justin. Huna Maraka. Got a few questions going on. We'll get to those for sure. Kevin Johnson's in the house. Thanks, Kevin, for showing up. Christina, nice to see you, my dear. Michelle M., you as well, Michelle. And we have Dimple and we have Mike. Okay, so let's get started. And just a reminder, anyone who has any questions, you can just put them in the chat and I'll get to them before I leave today. So we'll be here. I don't really generally cut anyone off. Now, if some people pop in, we're literally at the 2 hour mark or after, and it's been, we've gotten through every question, I might say next time. But anyone who's been here, and popped things in earlier on is fine. I see a new member, Christopher Butterweck. Hi, Christopher. That's really great. Thank you. Um, where are we at here? Clean your room. I could use someone to clean my house. Clean your room has a hearing on, today. That's today, right? Clean yo? Yeah, today's the 18th. Hope you're not missing your hearing. All right, let's get to it. So Christopher, new member. Thank you, Christopher. I really appreciate. And hello, Justin Zane. All right, so let's get to Huna Maraka's question. Good morning, Joy. Thank you so much for taking our questions. It is my pleasure. Is it common for DDS to give a cutoff date for medical records? Yes. For review for a claim by December, whatever. Yep. And then sit on docs for a review. It's very common for them to give a cutoff date, I suppose, because you can't have your case sitting there for 15 years, right? It's either you get your medical records into them, or if you leave it up to them, you hope that your doctors comply. Um, either way, it's really your burden, your responsibility to do that. And so there has to be a cutoff date. I mean, we even have people that are like actively treating. This could be at the time of a hearing even or after. And the judge will say, when I say, can we have a little bit extra time to get this one extra record? They'll be like, oh, we can't keep, if treatment's ongoing, you can't keep it going forever. Yes, that's absolutely true. But if it's something important like an MRI is coming out or something diagnostic and objective, that is the kind of stuff they're more apt to give you a little extra time for if they know about it. So you have to let them know. With regard to the perception that they're sitting on the docs for review, I would say that's probably not what's happening. It is either the doctor who will end up reviewing the documents to find an RFC for you. You're in his inbox and he's getting to it, or he's on vacation. Do you know what I mean? So I wouldn't assume that they're sitting on it. I don't think that's generally what they're doing. If you have an adjudicator, that's probably not the case at all, actually. So um, it's just that, there's people doing different roles. The adjudicator is not the medical expert, so he's not going to be the one uh, deciding your RFC generally. It would be the medical expert who his decision and his thought process ends up being noted in the DDE, the Disability Determination Explanation, which is created for every decision. They don't send it to you. So you either have to ask for it and get it, which, if you get someone at the field office who's willing to send it to you, they should. It's their job, but it can be hard to get medical records through them. Or if you have an attorney or a non-attorney rep who has access to the electronic file, we should see it up there. That started in 2025 when they made that transparency accessible by us, which prior to that it wasn't either. And it's really, really helpful. I mean, we have a whole process now for evaluating it, because we get it so much earlier now. And it can be helpful for recon or going to an ALJ to see what is it that they said that, they relied on to support a denial. So Hunamaraka, I'm going to butcher that, I'm sorry, says, I submitted in September 2025. I think you mean you filed in September? Date of injury is February 2025. Okay. Multiple body parts with multiple surgeries. I'm sorry to hear that. Other surgeries are needed. Maybe you haven't had them yet, or maybe you've had some. Only have 1 year left of, what is that, temporary disability? That means nothing to me. Is that workers' comp? Also receive 70 plus hours a month in IHSS included. I would submit that documentation. I mean, that's what, like 15 hours a week you get? No, something like that. Almost 20. That's in-home services, right? I'd like to think that the fact that you receive that means you've met a big burden at your local for a local program where they're actually spending a lot of money on you, taxpayer money, to get you in-home care because you're probably not really great at ambulating, not safely traveling in the community by yourself, that kind of thing right now. And it could be temporary, but nonetheless, it kind of, to me, it says an acuteness or a severity right now, and that can only help your case, because it almost defeats the statement that we find that you're breathing and you can move your limbs about a little bit. So there is some job you can do. Well, if I can't even negotiate my community to go to a doctor or to do certain basic at-home needed things for basic survival and decency, that would almost fly in the face of that. That would be my argument anyway for IHSS. PTSD from assault at work. Oh, that's lovely. I'm sorry you went through that. Okay. So by the way, you're very early in the process, so I know you feel like it's taking forever, but talk to some people here, you'll find out that not so much. So you're in California, you are 49, which is a tough age to prevail on. So all the things you're pointing out, though, are really important because it does speak to a severity. I know you're saying, I'm 50 in September. That means you're not 50, you're 49. And I know you're probably hoping that you can get that borderline age thing attributed to you. So time will tell. Qualified for LTD, that almost means not very much because LTD has a completely different definition. Some LTD policies, and by the way, that's long-term disability for anybody who doesn't know, some only require that you can't do your previous job. Let's say you were a brain surgeon and you have a damaged little pinky finger. And they say, all right, he can't be a brain surgeon anymore. And that's what the policy says. It says if you cannot do the profession you are highly trained for, then we will pay you, regardless of the fact that you could, drive a taxi. So LTD is where you negotiated, in a sense, the terms of what you bought. In your case, it was probably an employer that bought it. But nonetheless, the stringency is far less. The definition of disabled, it's easier to be disabled for LTD purposes. Those terms are easier to meet than the SSA, which says you have to be unable to do any job in the economy, even one that a third grader could do, so long as you can't do it. Any job that exists in substantial numbers, of which there are many third grader jobs. So, you have a much higher burden, and it's usually much less for LTD. So the question, he says, is could I be getting close to a decision? That would depend on, have your doctors put up everything? If they have, is it good and articulate? Even if it's not articulate, decision will come fast. It'll just be a denial. So you want the quality to be there. And there's no way to know if it's close to a decision. Did you do a function report yet? I'm guessing you did. And the work history report, if you had to do one. Have you been keeping them apprised of all your ongoing treatment, or are you making it seem like no more treatment, all done, I'm good? So if you have ongoing treatment, you want to keep letting that adjudicator know what's ongoing. We now actually send them date by date hey, he went to this doctor on this day. I'll do a letter with like the last 5 dates of the last few weeks if the person's really vigorously going like I hope they do. Those are the people that tend to win on initial and recon. And the ones that are a little more hush-hush about it, even with us, their case can take a bit longer. And then if they're not going at all, of course, it's probably going to be a denial. But we try to figure that out early because we don't really want to be around for that. If our work is not able to be, used by a case, it's kind of pointless for everybody. So can't tell you whether you're close to a decision. Huna Maka. No, Huna Maraka, because I don't know what's gotten in. You can call your adjudicator. If you don't have an attorney or otherwise represented, you can call your adjudicator and say, hey, what all you have in? Did you get in everything? And do you know that I just went for an MRI? And then they can get it, or they'll say, do you have a copy? And you can send it up to them. Hello, Kevin Johnson from Tennessee. Oops, my clicker not working. Come on. There we go. Weather's a bit strange. Are you cold down there, windy? We had tornado watches. That was fun. Last week there was one and it took the gutter off of the tiny house. But you didn't really need gutters on the tiny house. This is where I'm at now because there's no foundation that water can get into. So the convenience of the gutter really is so that when you go in and out of your house, you don't get tripped on. It didn't rip off that side of the gutter. It was the other side. So we're not in a huge rush to fix it, although we will eventually probably. Maybe. And Christina from California. Michelle. Thank you, Michelle, for telling me you could hear me. Mike Page, hello again. Dimple, hello again. Clean Your Room is in the house. I don't think we've met Clean Your Room. That's something that I say a lot, though, to my kids. Clean your room. And I could use someone to clean my room. But it sounds like your phone hearing is later today. Yeah? Fingers crossed for you. I hope that you hope it goes good for you. Fredabug is in the house. Fredabug had a good result. Yep. I appreciate you telling me that when it happened, by the way. Freda. Had the hearing January 13th. Okay, this gives you a little perspective. My attorney and I both thought it did go well. The judge didn't even give me a chance to tell my story. That's because he already knew he was going to award you. But I won, and my back pay is huge. I am beyond happy. So glad for you. That's amazing. I think you just found out recently, right? So guys, just for some perspective, because you'll always say, when will I get my decision? We can't say when, but here's an example of, it looks like it was about 2 months later that Freda got, his or her decision, and it was an award. So VWAP, hello from Poconos, PA. I'm in Poconos, PA also. Well, actually right now I'm out by Harrisburg, but half the time I'm over in the Poconos working from there. Okay. Clean your room. Said it's the 19th, so it's tomorrow at 8:30 a.m. Nice and bright and early. JC's in the house. Hi, JC. On March 12th, it was announced that all CDRs will be done in-house by SSA. Yes, I had a video about this. I put it out for you guys. It'll be done in-house by SSA instead of by the state DDS. What impact will this have on CDRs? We shall see. Will it also change who processes the short form CDRs? I don't know. They didn't reveal that to us. I think I don't find it to be bad. Remember, CDRs were shelved for a spell because in 2024, 23, all that time period, the administration was so ridiculous. They couldn't put one foot in front of the other. And the initials and the recons, that was when, for the first time in my 20-something years doing this, the initials and recons were not taking your typical 4 to 6 months. Suddenly we had people on 15 months. So they were not, they're keeping their staff, up to, well staffed. They did have a hiring freeze. That's when they did that. Everything just went worse. And so they announced that they were going to stop CDRs. I think this is 24. So that the DDS state workers could just do um, initials and recons. Well, of course, then you've got all these CDRs that are now overdue. And so now we come to 2025, and they're like, okay, I think at the end of 20, I can't remember if it was the end of 24 or early 25, they resumed CDRs. I think it was end of 24. So they put them on hold just to get through some backlog of initials and recons, which didn't really do too much, I didn't think. And then we're going to start doing CDRs. But now think about it. If you could still have your backload of initials and recons, at the, in the state offices doing the federal work, and now you throw at them all these backlog CDRs, plus other CDRs are due. And, in a sense, I know people hate to hear this, you deserve your CDR so you can get it out of the way and keep continuing on with your benefits rather than having that immediately over, fearfulness over your shoulder. So now they had all the backlog CDRs that had to be done while they're still trying to do initials and recons, and all the new CDRs that are coming due are loaded there. So I think the pain point was for people who are filing on initial and recon, like most of you probably are, and their things are taking forever. We're always talking about why is it taking so long? Well, because now these people have to split each they have to split their time between CDRs and initial and recon, and some of them have to be working on this one. It would be nice if they could all be getting through initial and recons. So I think it might not be a bad idea, and because there is a slightly different process, having the CDRs, whether it would be a different state branch, but if these state leaders are not hiring sufficiently in their state programs to have the people to do this, that's another thing. And you can't necessarily control that from the federal level. So maybe pulling those CDRs back, let the state people who have been working on initials and recons focus on that instead of splitting everybody up for CDRs, and then just pull the CDRs in-house. I can't see why that would be a problem. I don't know that it would change anything with a short form versus a long form. But it might make it more unified. I guess we'll see. But I'm pretty sure they want to get rid of that backlog, get through it, and make everything more timely so people can really trust when they're going to have their CDR instead of it be something hanging over their head for 8 years when it should have been 5. You see what I'm saying? So any kind of improvement, I mean, you don't know unless you try. Since it's been broken, why not try? JC also says, will it lead to more cessations? There's no reason to think it will. There's been no indication. No rules have changed. So I don't find that would be the case. I mean, if you have more people, because of the lag in time, JC, who have recovered, because remember, a lot of disabled people recover and they can go back to work. If you have more people that have recovered, because there's been all this extra time, numbers-wise, I would expect you to see more cessations because there's more improved, healthier people. But that would be from a numbers thing, not a percentage thing per se, overall. So when you look at stats, remember to look at the important things and don't let them manipulate you. You know what I'm saying? Like, because there's many ways to twist a stat. So, yeah, so I don't have any reason to think any rules have changed that would make people, legally not be disabled anymore, as opposed to before. So, does this change or violate whatever rule which you say says indicates that states are mandated to cut CDRs? I don't know. I'd have to read it. So I'm not going to do it here while we're doing this because that would be rude. But I could try to look at that later for you if you want. And does it say that states are mandated to conduct CDRs, or are they just mandated to conduct the ones that the federal government sends them? You follow? The language is going to be really important. So we'll take a look because I have no idea what that says. If so, can you facilitate getting them to undo this? Can I facilitate them? I'm a practitioner. I'm not a legislator. But what you should do if you have a big problem with this, and I'm not sure why you would, JC, it doesn't seem appropriate. But I mean, it doesn't seem like there's any indication why you should think it's a problem, unless there's maybe clickbait going on out there that's telling you it should be. But they tell you everything should be. And then by and large, they are wrong. So we see it time and time again. So just be careful of the inflammatory clickbait things that are designed to get you to click and be afraid so that you keep clicking. Click, it's Everyone probably here knows what I'm talking about. It's crazy. Um, but no, I'm not a legislator and I'm not a lobbyist. If you're not working and you want to go do that, you could do that. Run for something. And then, because if it's a congressional act and it mandates something, then they can't do it. But I have a feeling that's probably not the case. Um, or there's another law that maybe you haven't read, because you got to remember all the laws kind of like overlap and cross-reference each other. And there'll be one way over here that says, with regard to USC 421, an exception can lie where blah, blah, blah. And it's something you didn't see because you're looking at this, and this one doesn't tell you to go look at that one. That's how the laws are. They keep people confused, right? So we'll see. We'll see, JC. I will look at your law, though, and if it's not something that's completely boring for everybody else, I'll just try to throw something into a video and I'll post it for you. So just pay attention, all right? I'll try to do that in the next week, too. Kevin says, where would my diary be on award letter? They're not always in the award letter. In fact, they never used to be. I don't even know if they are regularly now, but that was never something. But you can just call your field office, Kevin, and they should be able to tell you what your diary date is. Yeah, if it's not in your decision by the judge, Kevin, that's because the judge didn't provide an opinion on when it should be. He doesn't have to. It's not really his job. His job is to find out whether you are disabled under this and get you your benefits. I have seen judges sometimes that'll say, in light of the therapies going on and the recent surgery, she's still disabled. However, one would expect improvement due to the surgery and recovery. And I'm just thinking of one particular case. The person was like 48. So she was young enough. Like if she was 63, they might not say the person's going to bounce back and recover enough to get a job full time. But at 48, so I think her diary date was like 18 months from our win. And strangely enough, then COVID hit. Silver lining for her, right? But because then it got delayed or whatever. And then by then she's in her 50s. So then there was a slightly different rule set that applied to her. Let's see. Yeah, Kevin. So just call your field office. The judge didn't offer them an opinion. Maybe he didn't think you should be. And they don't offer that up either. So it might be where he didn't even think that there was something more immediate to review you on, a quick recovery. So he left it up to this people that specialize doing that at the Social Security Administration. Hunanamaraka. I am sorry. See, that's long, so it's going to take me a little practice. So you have to come back every week, and I'll keep practicing. Yeah, it's workers' comp. Thank you for your guidance. You're welcome. Yeah, TDD. Was it temporary total? Temporary total partial? No. When in doubt, I always ask my friend Sharon, who is a workers' comp attorney in Jersey. And she's a partner, actually, at an awesome firm there. So she's my go-to with workers' comp. And I try not to have the need for go-to workers' comp because I don't practice it. So I just send that all to her. VWAP says, can you be hired to assist in filling out and filing spousal benefits for my Social Security based on a common law marriage? I have a letter from an attorney stating that my common law marriage is legal. That would just be so expensive, though. Honestly, it would be like by the hour. It's not cheap. Particularly when I deviate out of Social Security. Yeah, it's when I'm doing something by the hour, it's not going to be cheap because it totally it'll take away more time than I even charge for, usually, because then I end up, drafting things for people because then I feel bad because it would be hard for them to do it and whatever. So it isn't cheap, to do an open-ended thing like that. I mean, I don't know why you would even need to present the proof. A lawyer says that he thinks it's legal. Okay, so that's helpful. It's obviously not going to be binding on the SSA. You're probably going to want to provide the proof. If you were to prove it under your state laws, this is just a quick little piece of information, not the full scope, of course. If your own state recognizes you as married, common law, so go look up the federal government will embrace, for lack of a better word, what your state has decided you are. So not what that attorney decided you are, but what the state has decided you are. So do you have certain state rights that are only available to recognize marriages? For instance, if, gosh forbid, somebody passes away, and you might not know the answer to this yet if it's never come up, hopefully not. If the state recognizes, for instance, spousal inheritance rights for a common law marriage, and you have that established, then that would be taken as probably gospel by the federal government. They're not trying to dictate over states' decisions on marriages. They just need to know you're married under the law. And since marriage laws are state governed, they embrace the state decision on that. But there is, I don't know if it's POMS or Social Security rulings or code sections. I'm not sure, VWAP, but that do discuss some of the things a Social Security staffer should be looking at in terms of evidence to determine if some, pretty sure, if someone has met the burden of meeting their own state rule. So get the state rule. So see here, SSA, and this is what you do when you don't have anything adjudicated by the state, because thankfully nobody's passed away. You haven't had to avail yourself of that. But you could say, here's all the evidence that my state requires. Under state rule, you could see. So you need to like, and imagine how much is that going to cost you if I were charging $300 an hour? It would probably cost you $10,000. So it's something you could do yourself. And you'll know if they reject it because they'll deny it, and then you appeal. And then maybe you're like, well, maybe I need to buy a little time. But do you see what I'm saying? It's something you're probably going to want to do yourself. Yeah, unless you get like some sort of pro bono lawyer who can do that for you pro bono, which that wouldn't be me, but I do strictly Social Security things pro bono when I'm opting to do that. Huna Maraka is saying he or she uploaded everything, so you're keeping the DDS informed of all your ongoing treatments and visits and all that stuff. That's excellent. Good, good, good. VWAP says, my attorney says SS is more complex and that an SS attorney would be helpful. It's just going to be no, it's not just filling out forms and submitting forms. That part's easy. People do that every single day. You could do that. The filling out the form, because you're doing survivor benefit, I think you said. You don't have to prove you're disabled, right? Or do you? If it's a disability fight and the only way you're going to get it is to prove you're married because you're getting it maybe as I don't even know when that would be. That would be a survivor benefit, and you're not talking about survivor, I don't think. Let's see, VWAP, where are you? I'm scrolling up to see if I can find. All right, why don't you clarify what you're trying to. Are you trying to get a retirement benefit by proving that you are married to somebody, you or somebody else married to you, to prove that you are married to somebody and you want the spousal benefit from them because you don't have your own work record? Is that what's going on? In that case, you don't have to prove disability. That's the big battle. That's what all of us Social Security disability representatives do. We're doing the medical proof battle. The other stuff is a little more rare. Like yours would be, yes, more rare, but it's gonna be costly. You can try it on your own. Get all the things that are required to prove marriage. Look it up. Maybe you want to buy an hour or two, and I'll look it up and give you the rules that you're gonna have to follow. But you really don't want me being your little secretary filling in your paperwork, because that's gonna take a couple hours, and then you get charged for that. So you want to do your own secretarial, you know, because meaning the typing or the whatever, because otherwise it's going to cost you a lot. So you still have to gather the information yourself. If what are you gonna hire a private investigator to go get all this stuff? That's gonna cost you by the hour. Do you see what I'm saying? You have got to do a lot of the legwork yourself, unless you want to pay out the nose. It's just the way it is. Huna Maraka says here she has surgery on the 2nd of April. Fingers crossed for you. Safe recoveries on that, Huna. Now we have, I think, a new person in the house. Yeah, what is it? Yitzlin? Yay! 2 questions. So it's good to see you, by the way. I don't think we've met. My ALJ appeal is due today. Go right online and file it. If I don't submit it by today, does that close out my case? Yes. I'm applying for mental illness. Yes, it will. It will close out your case. And it is so easy to do. Go in, go where they say, hit the appeal for ALJ, put in your information. I hate to say if you don't, if you could stick in one doctor, that would be ideal. And then in remarks, say, I have other doctors, I just couldn't get them in here because my mind is going crazy and I can't really negotiate this. But I had help just to get in here too. Because what you're doing now is the notice of appeal. It's not going to be, you have the opportunity after that to then get all your doctor stuff. And you have to get it up to the ALJ. So you have to be able to upload it or fax it, follow those directions. But you do have to, if it's due today, you have to get it in today. Now, I don't even want to tell you about the 5-day. We're assuming you got the, I'm assuming when you say it's due today, you've included that by reading your denial letter where it said exactly where the dates start and end. But there's no reason, even if you did have 5 more days, to wait till that 5th day. Because if you know you're going to be in the same spot you are today, because you're still like, woo, I don't know, I can't put in my doctors, just get in there. Worst comes to worst, you don't put in any doctors. All right, you're going to have to do something if you're going to plan on winning, but it buys you time because you're still going to have all the time before a hearing. But I would get on it. And hopefully you have a trusted friend or family member who can help you because, if you can't do it yourself, you kind of want to get someone who will lead you through it. And I know that's not, it's sometimes easier said than done. But just get in there and get it. If appeal is in your best interest, which, for most people it is, get it done. It's a notice of appeal. It's not where you're proving your case. They give you an opportunity to put all your doctor's stuff in there, so that gives a starting point. But if you can't, at least get the appeal to go all the way through. When it says, thank you for submitting your appeal, print that so you have proof. So if they ever say, we never got an appeal, you'll be, yes, you did. I would print the receipt. There's a little link in your acknowledgement that you've appealed that says, we suggest you print out this receipt or something like that. Open that up, print that out. Yeah, I would do that. But technically, you can appeal without putting in all the details they would prefer you put in. You just got to put in certain ones, like the name, the social, match it up, etc., etc. I hope that helps. Yeah. I'm going to call you Ya. Or should I call you Yay? Yay. Let's see. CG's in the house. Hey there, pal. David's in the house. David V8. I love V8. Says he got a letter from the appeals council saying remand for missed medical records from lawyer and sent to a different judge for review. Ooh. Updates have disappeared from SSA website. Decision? So, David, are you saying the appeals council sent you a letter saying we've looked at your case and we are remanding it back to the SSA or back to the judge due to missed medical records from the lawyer? Does that mean the lawyer submitted them, but the ALJ didn't put them in the file and sent to a different judge? So they're not sending it back to the same judge, but to a different one. That would generally be for another hearing, David. And of course, when y'all know that whenever you're in line for a hearing, even if it's your first time, they can always, if they find it suitable, do an on-the-record review and award without having to have a hearing if all the medical records make it indisputable in their minds that you're disabled. They don't need your testimony to corroborate or what have you. So yeah, I mean, so technically they get it there. There's, in theory, they or their attorney advisors review the case. Hey, can we give an OTR? Oh no, all right, schedule them for hearing. Updates that disappeared from the SSA website. I don't know what that means. You mean when you go into SSA, .gov and look at your account either through your phone or online, you see updates have disappeared. What does it say? You're waiting for hearing. Where does it say your status is? CG, you're in Tennessee also, huh? You and our other pal in here, Kevin, I think, Tennessee. Canova Henry's in the house. Good afternoon, everybody. Philadelphia, PA. How do you like that Philly there, Canova? Are you city Philly or outskirts? Yay says, they said they didn't receive my medical records during my first recon. But I had called the adjudicator 2 times to confirm they had received it. Well, received what? They might have received one that you talked about, but then they didn't receive a different one. Or they got them once. Sometimes then they'll re-ask for an update because enough time has lapsed, and maybe that one they didn't get. So it's kind of hard to tell from just vague statements. Second recon denial letter said they didn't receive any. I'd have to read it. I mean, I'll trust you that it says that, but it doesn't really make sense. And I'm not sure what you meant by second recon denial letter. There should only be one, right? Was there something? Hmm. Dimple. Hi, Dimple. I'm wondering when my local field office will get their transmission fixed. You mean the fax? So they will advance from neutral. What does that mean? Oh, advance from neutral. Yeah. Oh, JS, that just saying. Yeah, like will they process like attorney paperwork and such, right? Get it all connected. Proper Dame is in the house. Hi, my ALJ hearing was October of 2023. Okay, so we're talking 2.5 years ago. Denial was December of 2023, a couple years ago. I was 53 at the decision time. Should the grid rules have applied? They did apply. You didn't meet them. You didn't submit evidence that had you proved you met the 3 prongs you had to meet. And those 3 prongs, you guys have heard me say this before, at 53 would have been proving that you cannot do light work. Even something as simple as light work you cannot do for physical reasons. It means you had to be prevented from lifting up to 20 pounds occasionally during a workday, and or you were not able to stand on your feet for 6 hours out of a day, that you were something less than that. So, and then the other prong would be, and you're not able to do your prior job that existed in that window at that time, and at that time, there was a 15-year look back. So that was the rule you had to meet. The rule has changed now, Proper Dame, to 5 years. It is the biggest, best rule change on behalf of claimants I've ever seen. And it makes a world of difference for awards. And it also helps CDRs. So at your time, I think you had to prove that all those jobs of the prior 15 years at that time were not doable by you for medically proven reasons, each and everything. And lastly, you had to prove that not only could I do any of those prior jobs, any of the skills I learned for those jobs, I couldn't then go and transfer to one of those sedentary jobs I could still do, a sit-down job, basically. Since, you had to prove you couldn't do light, that would mean you could still do sedentary. You could still win at 53 at sedentary, but you have to prove you can't do your prior job, and you have to prove that you can't take those skills from that prior job and put them in a job that would be sedentary that you could do. Yeah. So they did apply those rules, and you failed to prove them. That's the problem. Through medical evidence, of course. It's always through medical evidence. Yay says, I was in SSDI previously. Okay. Recovered, went back to work. Okay, I'm glad about that. Disabled again, applying again. I kept my Medicare. Any idea if I'm still allowed to keep my Medicare? How would I find out? See, when you went back to work, you kept your Well, if you're still on your Medicare while you're reapplying for your SSD, yeah, I would kind of think it would still continue if it's like under that 90 something month parameter. Not really my forte. Yay, I'll tell you, I don't, I'm not a Medicare practitioner, but that's something I would, look to. If those, I mean, they were saying you kept your Medicare while losing your SSD. It sounds like due to working income, not because there was some great evidence that said you were better, only that you found a job you could do that might not exist in substantial numbers. They don't really have to look at it because they could just get you, you lose it because you're now earning and it's not, you're not part of that um, under SGA business. I would kind of think it would still continue, but I'm just saying that because it seems logical to me. If they have a 90-month something rule for those that are not proven to be medically improved, only financially they went over the limits and that's why they lost it, I would think that would still apply. However, if you were to lose because they find you're no longer disabled, then that might change it because now you're not losing it based on earnings too high with no medical improvement, but you would be losing it based on medical improvement. Just a thought. Um, you can always try, well, I always say try to research yourself too, but you can always try to call your field office and see if you can get someone who knows specifically about your case with that. I would say take everything you hear with a grain of salt and try to do your own research to confirm things. Kind of like when you do a Google search, you double check, right? Or a chat search or something. You don't just trust either one of those. Um, okay, Shub is in the house. Hi, Shub. My diary date was on my approval. Okay, so you see, guys, it's not consistent. And when your approval, was that your ALJ decision or was that your pre-ALJ? Was it, trying to recall where you won at? I think you won at ALJ, right? Or no? Egypt is in the house. Egypt says, hi, I received a CDR short form after 15 years. I'm 56. Should I be concerned? Well, I wouldn't say be so unconcerned you don't fill it out. Don't be that unconcerned. But short form tends to be that they don't really foresee that you have a reason to be improved or that technology has changed that they got to ask everybody. Medicines have changed or whatever. 15 years is a long time. I mean, you were like a baby when you prevailed. And now you're 56. You've not only passed into the 50 to 55 range, you passed out of that and into the, advanced age like the rest of us. So that is helpful because you have even better rules working on your behalf for your CDR than you had when you won. Plus the 5-year, past relevant work period, which is also greater when it used to be back when you won, it was a 15-year rule. So I don't think you should be concerned unless you have been so improved that you have not even had to treat and you're just on disability because it's lucrative. Presumably that's not the case. Um, when we know we've improved enough to go back and get, a cashier job or anything else, it behooves us to tell the SSA, even if we're not choosing to get that job because we like hanging out at home more. And this is not you, obviously, Egypt. I'm just saying this in general. People get concerned that the SSA has to check to see if we're still disabled, but it makes total sense, guys, because people do, recover. We have modern technology and we have modern medicine and a lot of people improve, particularly younger people because of this. Older, it's harder. And now you are older, Egypt, so that those rules are really going to be a benefit to you, even if you had a little improvement. But just do what they're saying. I'm sure you've been treating reasonably well medically for all these years, and they're only probably looking at the last 1 or 2 years, since they delayed so long. You're probably one of the ones that slipped through the cracks. Probably you were on a mine, and those are the ones that they would put off even longer, understandably. Canova's in the house. Canova says, my lawyer did an appeal on my onset date because we were approved for my SSDI reconsideration stage, but not on the July 2024 date, but on the September 26, 2025 date. Okay. Well, as you know, there are risks to that, but sometimes it's warranted. And sometimes those risks are very small and it's worth it if there's going to be significant, I mean, 12 months, more than like 14 months worth of back benefits in play potentially. That could be a nice chunk of change that, yes, it's hard to forego an appeal. Hi, Shub. He says, hi, Joy. Hi, Shub. Du-du-du. Is that like three little walking people? What is that? Canova says, also, I will begin my first payment in April 3rd. So how much longer will I have to wait for an appointment for my onset hearing in Pennsylvania? That depends on how fast they're moving, right? Um, you appealed. Did you win? You won on recon and you appealed. So that would be to an ALJ. Okay. Um, they generally have to give you 75 days notice. You can waive that if you want it to be waived. I would be sure to keep sending in your medical records that you keep going to doctors, right? Because that ALJ will be reviewing everything about your case, including is he still disabled. You're basically opening up the whole case, which again may or may not be risky, particularly if you're older. You have the older rules applied to you, but it's really hard to say. I mean, could it be 6 months? Yeah, could it be less? Could it be more? It really does depend. Nicole is in the house. Nicole Olson. Hi, Nicole. Just came on to say thanks for taking the time to make content. Oh, that's really sweet. It's been extremely helpful. I'm really glad. That's awesome. Thank you for sharing that. Going out of your way to come on here and share that. That's great. Lauren Blackwell's in the house. Hi, Lauren. I think we met before. My judge came back from medical leave, is asking for more records. I've seen my normal doctor for seizures and a heart doctor who said my heart pain is likely tied to them. Is this enough? That I wouldn't know. Um, are your seizures infrequent? Then it's probably not enough. Are they 3 times a day where you have to literally always have someone in the room with you? Maybe not. You got to have medical proof of how severe it is, though. It doesn't hurt to have lay people statements, but for something like that, because a lot of times they occur at home. But yeah, there's no way to say whether it's enough, unfortunately. I will say seizure disorders are a tough one. They can be a tough one because a lot of times there's no one there to witness them. And just being on the medication and reporting to your doctor might not be enough. David's going to a different judge. All right. That could be good, David. It's certainly not bad. Dimple says, they're not moving and processing my info. Been sitting at the local field office for almost 3 months now. Yeah, it's almost at the time where we, have to start getting them poked by something bigger. Sorry, I was just referring to the fact there's a breakdown somewhere. Yeah. Although you've had some recent conversations probably, right? Yeah, we'll get it going. We've given them the breathing space. Now it's time to knock some heads. I will report later. Nina says, had my hearing and the judge didn't ask for hypotheticals. Ooh. He only asked if I would miss 2 days of work. No, he asked the VE if someone were to miss 2 days of work. What is your opinion? Remember, he doesn't say you. You don't have a copy of the audio, but your attorney could get a copy of the audio and download it today. They're usually available in less than 24 hours. He asked if the hypothetical person would miss 2 days of work, and the VE said the hypothetical person would be discharged from work, meaning they would be terminated. No one's going to tolerate that. That sounds very promising because if the judge did not ask and receive a vocational opinion about that resulted in some jobs being doable under any particular hypothetical, if there's none of that, then the only option generally, I'm not saying there couldn't be a rare exception, but we just don't see them, is that he's purposely carved it into a box, nice and pretty for you, that he can't climb out of because he didn't give himself a ladder to go pick a different hypothetical where there were jobs. You follow? Basically, if I have a hearing like this, I'm like, woo, afterwards. We do the little happy dance. But I still always say we don't sing till the fat lady does because we want that paper in hand. You know, I want to see it just in case some weird. I'm just that kind of cautious person. I need to see it. Oh, and I should go back up and say, give me an example of why I say you have to see it. I came out of a hearing once, Nina. Um, it was a, strangely enough, it was a hearing I didn't really, I was very apprehensive about because the evidence, even though I knew the person was disabled, the evidence isn't the kind that the SSA prefers or the ALJs. It was like naturopaths and kind of doctors that I would like to go to, but if I have to prove a medical case, I probably need MDs and DOs. So it was kind of difficult. And then when we get to the hearing, and it's the same kind of situation where the judge asked these questions of the VE, and like the only result seems to be that the person, he's saying he's going to award. So I was thrilled, although I thought it was really strange because it's not even the kind of case that you would do that. Even if you were to award them, you would be ruling out, you would be giving the hypotheticals and then officially picking the one we like, after the fact for the decision. In that case, I was very happy about that hearing, although I was confused. And my client, she also understood the difficulties with it because we had talked about it for a long time, and we were waiting and waiting and waiting for a decision. And I get a phone call. Some of you have probably already heard the story. A phone call from the OHO, Office of Hearings Operations, which at the time was probably called ODAR, Office of Disability Adjudication and Review. They change the name every few years. And the lady said, "Hey, we have to schedule a hearing." I said, "No, we had a hearing. Went pretty well, thanks." Click. No, I'm kidding. I didn't hang up on her, but I wanted to because I'm like, no, we're good. Let's just go with what we had. And she said, "No, all of Judge so-and-so's hearings have to be redone." She wouldn't tell me why. I expect it might have been something where he was just awarding everybody. And it was a little suspicious that he wasn't applying discretion or maybe flat out rules, So interestingly, we had another hearing and the judge awarded us anyway. But there goes another year and a half, or whatever it was at the time. So you do want to get it in writing. We can be very optimistic after a hearing. And normally when I'm optimistic, it's not that kind of situation where I'm like, how could that have gone so easily? That seems weird. It's normally because I'm like, yes, that's how it should go. That is exactly how it should go. Egypt says filled it out same day. Let me just scroll up because now I'm forgetting. Oh, the CDR short form after 15 years. Okay. And you've been treating and doing all the stuff you need to do. If that's a picture of you there, Egypt, you do not look 56. You look very youthful. Okay. Egypt is saying, I have a doctor I see every 2 months. I'm presuming that's reasonably has a reasonable sense of frequency versus someone who goes not for 3 years, right? And chronic problems, sometimes it's longer than 2 months because it's like, but I would almost say you really want it to be, I think Jonathan and I were talking about this. He's like, well, if it's every year, I'm like, yeah, I think that's a little risky. I would kind of like to see, and this is for chronic problems that don't need monitoring, that, but you do need to have that following because you want that evidence in your back pocket. I'd like to see twice a year for those kind of things. If they go more often because they have a really cool doctor, fine. Then there's some things that need to have every 2 months. It could be that they have to have their blood labs looked at because the medication hurts the liver and they got to keep checking the enzymes. That's helpful too. So I do think, whatever the level of frequency is at, that doesn't sound bad at all, Egypt. Now, if it was a mental health case only, I don't think that would be sufficient because if you still have ongoing mental, so it's for the mental claim people, if mental health is what actually prevents you from working, I would be very disturbed if someone wasn't going weekly to therapy, because if you still can't get out of the house and be reliable out in the community, It's pretty severe. It's still pretty acute, you know. It might be a forever thing, but at least it's being addressed. I just think because the mental being so subjective, they want to see more, I think. Shub is bragging. Just kidding. He filed on his own. He was improved in 77 days. I love it. That's awesome. Brag it away. Brag it away. Darren says, I am 58, MRI on, I don't think we've met Darren, have we? Um, I'm 58, MRI on lower back, 5 bulging discs, 3 pinched nerves. The nerves are the biggest and most important thing as opposed to the bulges. Osteoarthritis, COPD on CPAP, partially collapsed left lung. Oh my gosh, Darren. Left knee, and by the way, we're probably wombmates in different wombs. I'm 58 too. Left knee needs replacement. Right knee needs surgery. Has a GED. That's going to count just like high school, by the way. No transferable skills. How do you? Why don't you have transferable skills? And what does your lawyer say? Darren goes on to say, have continuous physical therapy. Would need an RFC report. Would I need an RFC report to? You know, I have videos on this. Why it's very dangerous to go ask your doctor who's not well schooled in the SSA definitions or the vocational expert terminologies that relate to the SSA things to qualify your RFC, what his opinion will be. They invariably others say the person is, they describe a person that is bedridden without saying bedridden. And then the SSA knows that's not true because they looked at your function report and you talk about how once a week you go to the store for 20 minutes. So you're not bedridden. Or they think a way of describing is indicative of a severely disabled person. And in their minds, it is. Someone who can't stand for 6 hours in a day, that is very limited. Most people can, even if we're like 60, we can do that if we're not impaired. So they will say, oh, he's really impaired. I don't think he could do 12 hours on his feet. He could only do 7. Well, that means not disabled under the SSA rules, right? That at least they can do light work if that alone is what's going on. So I don't think you should take the risk of that without, unless you know exactly what he needs to say, and you're not really supposed to lead him either. But if he were to be schooled a little bit in what the things mean, and then renders an opinion, hope it's the one that's going to lead to you being disabled under the rules, and in your case, Darren, under the grids. You really have to know what you're asking for and know how to ask it so that he doesn't have an open world in which to pick answers from, because the chance of him pinning the tail on the donkey in the right spot, if he's just pulling stuff out, is less likely than not, believe it or not. I think it's less likely than not. And if his records are good, your treating records are good, it's going to tell the story, and you don't need that. I'm curious about what your lawyer says, and if you don't have a lawyer, why not? And if you need one and you want us to take a look at it, at the top of the scroll, there is the evaluation that we take a look at first. It's really short and easy. And just tell them that you spoke to me here. Put your screen name on, and they will pass it right over to me. That's if you don't have a lawyer. If you do, you can ask him these questions. He's going to be working with you all along, and particularly if you have to go to hearing. Hopefully he's, working on it with you on initial and recon so that you don't have to go to hearing or wait that long. Okay, who's next? Okay. Hi, Dimple. You're sweet. Dimple says, so I have to repeat it. Be sure to like and subscribe. Thank you, Dimple. Egypt says, thank you. You're welcome. Jason McCarsky. Am I saying that right, Jason? Is in the house. Hello, had my hearing. The judge started talking football to me and my attorney. Oh, if he does that, he better award you. I mean, how dare you, take someone's time talking football only to deny them. I'm 49 and have severe spinal stenosis. I am so sorry to hear that. And severe degenerative disc disease with major depression. He only asked, let me just pop down. 2 hypotheticals, which is second was time off task and loss of concentration. Yeah, I mean, don't know the results. I look at it this way. I think to talk small talk with somebody that you're about to make or break their case and their financial fortitude going on for potentially the rest of their life, don't use them to talk. A judge should not be using the lawyer's time or your time to fulfill his need to talk about football. You know what I'm saying? Like, now if he's going to award you, then all's good. So I'm curious, when you get your decision, Jason, please come back and let us know and remind me why I'm asking, because I just think that would be really unprofessional and wrong of the judge to do. So I don't know. What do you think? Who agrees or disagrees? Canova says, can you please explain to me how the back payments work from SSDI and SSI? Well, if you can give me some specifics, that would be good. Back payments work for SSD. I'm just going to say SSD real fast here. They'll never pay back more than 12 months before the date you applied. So check that date and know that you're never going to get ones before then. And then potentially you're going to get from the onset date, whenever that is, or the latter if it's way before 12 months before your date of application, and going forward to the date of your decision or determination. So all those months in between. SSI, they don't go back 12 months before the date of application. That's why it's important not to delay SSI if you know you're going to apply. At least get a protective filing date that buys you the 2 months to get everything in, and then you'll be protected for those as if you applied 2 months ago. SSI does not have retroactivity, so it's from the date of application and forward. SSI does not have, and that's assuming they find you disabled on the date of your application, that there is enough medical evidence from that time period. SSI does not have a 5-month waiting period. SSD does. So whenever your onset date is, Canova, they have to carve out 5 months anyway as the waiting period. That would be unpayable. So, like, let's say you've applied 18 months ago, your waiting period would probably be the 5 months right before your 12 months before your date of application that are payable. Okay? I know it gets a little wampus to hear it in words. Sometimes you just got to make a little chart, a little timeline. Shub says, so if you get a 5 to 7 diary, take on a job to supplement SSDI, that side gig becomes your ticket to losing benefits? No, not necessarily. If you are not disabled and are proving it by your side gig, then yeah. But a lot of people work part-time, specifically at a job that does not belie what they said their claim was and what the SSA found them from their medical records and their statements to not be able to do. But if then you go out and do it, you know what I'm saying? Like, well, that's no longer true, and that's no longer true. So you just have to be super careful. The side gig can definitely be reason to get a review because you've just shown a difference. But a review, a CDR, most people fly through with flying colors. I'm not really worried about CDRs. For people who are diligent, for people who literally don't feel they need to go to a doctor anymore, but I'm still disabled. Well, you know, you kind of get what you ask for. You yourself are saying you don't need medical care anymore, but you did when you were applying. So something's gotten better that you would say that. You follow? You got to think of it like optically. What does this look like? Circumstantial evidence. What does it look like? Yay says, thank you for taking the time to answer. Time to go finish my disability report appeal. Yeah, it's taken me 3 weeks. Yeah, I don't know if you can get a representative. Yay, you should probably try to do that. It makes it easier. I mean, maybe ask them if they are hands-on with forms and stuff. You know, some of them don't at all, and then some of them do. I'm sure there are some like us that say, listen, give us the data on this thing, then we are going to draft the real thing. So you don't have to be super neat and worry about your lingo. We do all that, but we need to know what's going on currently in your words so that we can then, you know, make it accurate and responsive to the questions in the appeal for you in the way that's most accurate and most helpful to your case. Canova says, My lawyer applied for SSDI and SSI in July 2024. I haven't received nothing since 2024. Well, if you're still fighting it, that would explain that. You're still fighting it, right? So if the judge approves my onset date of July 2024 of my right knee, proof of broken, how much back? Okay. Thank you. That gives me some numbers to work with. So if your onset is July of 2024, so whatever month it is, so here we're talking about July of 2024, your first full month of disability, of being disabled, is August. August, September, October, November, December 2024, those are your waiting period months, Canova. You're not going to get paid for them. You were disabled during them. The SSA determined that, or the judge did, but you're not going to get paid because that's your waiting period. What do we say, through December? So your first back benefit would be January of 25, all the way to whenever the judge's decision comes out. That'd be back benefits for SSD. Now, if you filed for SSI at the same time, like you think you just said you did, SSI doesn't have that 5-month waiting period. So the application you did in July for SSI and the 5 months you didn't get SSD, assuming you were poor enough in the rest of your life to not kick you out of SSI for those months, you could get SSI for August, September, October, November, December. Remember, your SSD kicks in January of 2025. Now suddenly in this month you have SSD income, retrospectively when they're looking at month by month, and assuming that that SSD is something super respectable, it's gonna bump out your SSI eligibility for the future months because now it's gonna be SSD. And I don't want to say what the amount. It's about $1,000. If you have something less than $1,000, you might get a little bit of SSI in the prospective months. But if you have like this $1,200 SSD, you're not going to get SSI because dollar for dollar, it's going to boot out your SSI, right? It gets counted as income. So I hope that clears it up. So the 5 months of SSI that you could get during that waiting period, I mean, that could be almost $5,000 depending on what your other finances are doing and your incomes, in-kind income and all that. I always say don't leave it on the table. Just do both applications if you are, if you don't have a working spouse, so there's a lot of things to look at. Like if you have a working spouse who's pulling in the dough and you're the disabled, you're not going to be able to because their income is going to be imputed to you, of course. But for single people, that is definitely something I would not leave on the table. $5,000 could actually pay your attorney fee. You don't have to take any of it out of the SSD. Just saying. Anyway, Canova, I hope that helped explain those dates. Those are really helpful. It's much easier when you have some concrete dates. Jason says, Jacob Makarski says, my judge also did not ask in question about how much I could lift or how far I can walk. He did speak about military and was interested in my therapy. Oh. He didn't ask. Now that stuff is all in your function report, of course, but that's probably going back quite a number of months. And he talked to you about your military and it's in your therapy. I mean, we're all being speculative here, but I mean, that's not only did he talk about football, but he talked about your military, which is technically not relevant. So I'd like to think that's just because he had the hearing to get a facial on you, just help some pull together, and because he had to do the VE anyway, and you're entitled to be there. But I'd like to think that that's positive, and he was just being a human being because it's not like he's using your time to, titillate himself with football. You know what I mean? And the fact that he inquired about your military and stuff, I don't know. That's like two things now. Therapy is arguably, related to the case, but the other stuff, not so much. All right, we're at 2:09, guys, and I don't see any other questions. Are we going to cut out early? It's up to you guys. I'll give you just a minute or two more if anybody wants to pop something in. Jason says, thank you. Maybe he was lonely, just wanted to talk. I mean, I like to think he's got enough people to talk. You know what I mean? He can come on here and talk to us anytime he wants. Well, once a week anyway. So I don't think, maybe he was just trying to be warm, you know, to you. Maybe he just was having compassion and he's awarding you because otherwise it would be really inappropriate. That's what I'm thinking. Because if he's going to award you, and a lot of times they know before the hearing what they're inclined to do, and then you'd have to do something really fouled up to blow it at the hearing. Um, yeah, maybe just trying to, show humanity of, as SSA judges, he's awarding you, but he just want to show that you're a person too and all that. Kevin Johnson says, so I'm 60 years young. Will I get a diary date? Yes, I believe you will. Yep. It might be 5 to 7, Kevin, and then in which case you're not really gonna have to worry about it. But they have to assign something. Because what's to say you're not someone who should have one in a year? You know? Amy Stark is in the house. Throwing something at the last minute, Amy. I'm glad you did. My accident happened in 2023. So of that, be my app. AOL. Do you mean your alleged onset date? That would be AOD. Oh, yeah, AOD. Um, if you have been unable to work since whatever date in 2023 or had to switch to SGA work, much part-time and far less money. Yeah, that's probably, I mean, I don't know your situation, but that if you have been unable to earn and have not been, other self-employed or W-2 or what have you, um, that would probably be your onset date if it's from those injuries from an accident. So I hope you're okay. Nina says, is the CDR appeal same as SSDI appeal steps? Um, Good question. I've never done one. Like people come to me after they've already appealed. um, and I don't normally do CDRs, but I do have one right now. I mean, we keep them to a minimum. That's like a super tight category. Presumably. I'm just trying to think if the letter would say the same. I actually have one. Maybe I'll take a look at it after, Nina. But I would say, yeah, it's usually the same because now they're going to start working it up just like they do the regular thing to see if, what your current medicals are and all that. So you want to, if you haven't been going vigorously for treatment, and that's why your CDR had to be appealed, Nina, now's the time to get all those diagnostics updated. I don't know what your particular medical problems were, but if it's suitable for diagnostics, like physical diagnostics, like MRIs and all that, now's the time. Now's the time, and or physical therapy. People. It's a shame when people wait till CDR to say, oh, I should start being serious about my stuff. Yeah, that's something you should have been doing all along, but it's not necessarily too late, but you have to hop to it. Dano B says, hello, thank you for what you do. You too, Dano. Thank you for being here. I don't think we've met. Thanks for stopping in. Okay. Dano B says, my CE confirmed my diagnosis for bipolar 1 for anxiety for CPTSD. That would be the chronic PTSD. And I also, or complex sometimes. And I also have a right knee full replacement in which the x-ray showed a healed fracture in the kneecap. How are my chances? Can't give you chances. I'm not a bookie. But much of it's going to depend on your vocational profile, Dano. So that's your age, education, and experience. And I would say education is the one that you can 99.9% of people don't have to really consider. So, it really depends. You have physical and you have mental. If you have any other physical, such as back issues, like does your back start to hum after a while when you're doing something gentle, like sitting or standing for a while? Then you probably should get your back worked up. Just saying. And again, the vocational profile is going to, because it tells us which rules apply to you. So it's hard to say chances. Not that I would give you strict chances anyway, but when we, don't know which rules are going to apply, it'd be kind of irresponsible for me to just guess. Down at B, I also have a lawyer. All right, so that tells me a couple things. The lawyer had faith in it, and he knows your vocational profile, so he found it sufficient enough, along with your impairments, to think it was worth a shot. So that's good. I'm glad you have a lawyer. Amy says, what is CDR? Okay, Amy, CDR is Continuing Disability Review. Everyone who's found disabled and able to collect benefits periodically has to go through a CDR to confirm through the evidence that they are still disabled. It's not as generally as vigorous as proving your case because you've already proven it, but you have to kind of have something to show that you still are disabled. So like stopping treatment after you win, even if you have a chronic problem that while the treatments don't help, is not wise. Once you prevail, you keep those fingers in those pots for follow-up and treatment, and where judges' notes are going to show that you continue to complain about this. You know, you're maybe there's medications, maybe there's not, maybe it's periodic injections, maybe it's if it's mental health, it's definitely got to be ongoing. If someone stops treating for mental health, big gaps, I think it's going to be a total, even more so than physical. Nina says, no CDR yet, age 63. I forget what you said, Dina. What did you say? I mean, Nina. Did I just call you Dina? So you don't have a CDR, right, Nina? Let me just scroll up and see if you're just asking about it. Oh. Oh, so Nina, you did win your case. Oh, we were just assuming you are because of the judge's questioning, right? Is that where we're at with that? Yeah, 63. If you're just winning at 63, what's the chance that you're one on one of those more rare things that just recover after 12 months of healing and can go back to work? It's possible. It's just like, but what's the chance of that being your only, this hypothetical kind of condition being your only impairment? So I think 63, when you're winning at 63, they could put on a 5-year or even a 3-year, but it might be when they get to 3 years and now you're 66 and you're about to be 67 in 5 months. I could definitely, because I think at that time they look at things and go, okay, this is her diary time. Let's put her to the side because what's the financial benefit, even if she is no longer disabled, it just hasn't told us, of doing all the money to prove it, since she's going to be getting retirement tomorrow anyway, right? Which then there's no CDR, and the CDR will not change that. So they definitely, I mean, that's a smart way to look at it. They have to look at, you know, financial smartness as well, not just the strict rules. And I think they're doing that now. Dana B says, I did talk about sciatica. Okay, you got to get on that. I would be treating for that. Ask your lawyer about that. Nina says, no, I was just curious. And that's totally cool. I think you're probably good, Nina, 63. Dano says, I also had another diagnosis that I can't name. I don't remember the proper name, but it was fear of being in crowds. Okay. So as long as you're treating with mental health for that, that could be, I mean, that's not the kind of thing that will um, negate all jobs, but it could negate um, jobs in crowds. I don't know what that might be, like working in a movie theater maybe, or, because a lot of people in there. SSDI, Nina. Okay. Oh, Dano, you're welcome. I appreciate the kind words. Hey, Siren's in the house. If you're scheduled for a physical CE and you have new evidence after the hearing, if you're scheduled for a physical CE and you have new evidence after the hearing that can help your case, will the judge look at the end and cancel the CE? So, Sirens, I know we talked about this. Refresh me. You had your ALJ hearing. He wanted a CE, and now you're going to the CE after the hearing. The hearing's still open, so yes, you can send in more. Generally speaking, you can keep sending in more evidence. I mean, there's a time when he's going to cut it off, but if it's before the CE, yeah, get him everything. Get it, get it, get it. If it helps your case. You know what I mean? It's something good. Because he's going to accept the CE evidence. So your case, they have like a date where they close the hearing is closed. They'll sometimes say it at a hearing. All right, so we're closing the hearing. Sometimes when I brought up in the beginning of a hearing, hey, we're waiting on an MRI to come in, they'll say, okay, I'm leaving the hearing open for 2 weeks. Hearing is open. You follow? And if I got something different from the MRI as well, I would definitely throw it up there. The chance of him not accepting it, I've never seen. Does he have a lot of power to not accept stuff? Probably. But that one might even have, if a judge did that, might even be grounds where the AC would say, we're going to remand this because he should have accepted it since he already was leaving the hearing open and accepting something else. And why wouldn't you want the full view of all the evidence, Judge? All right, kids. How are we doing? Anybody else have a question? Anybody have anything interesting to talk about? Anybody have good news? You know, bad news always spreads fast. Good news, not so fast. Anywho, all right. I'm just scrolling up to see. I think we're good. I think we're good, guys. I think all the questions are done. Y'all set? If you have any questions, I'll be here next Wednesday, 1 p.m. Eastern Standard. Oh, Shep Dad's in the house. Give me 1 second, Shep. And of course, we have our 12 o'clock dailies that come out. They've been it's been a little tight on those, but you can always post anything you're interested in. If you want, like, hey, could you do a video on X, Y, or Z? Or here's my situation. What do you think? If I can do a video, I will. If it's something I could just pop a little answer to, dictating into the post, I will. But yeah, if you have something you want on a video, just let me know. And you could do that under any video. It doesn't have to match the video you're under. Whatever pops in your head at whatever place you are, you can post it. I get to them all eventually, okay? All right, so Shep says, Shep, you are late to the game. Former LE. Do you mean, oh, I was going to say Leo, right? Without the O. Law enforcement. Thank you for your service, Shep. With PTSD diagnosis from psychologist PhD from 2016 and on meds through 2020. Did you have a particular question, Shep? Remember, yeah, got a particular question? That's an impairment, sure. Not necessarily disabling from all jobs, but so much will depend then on your vocational profile as well as your physical impairments, whether you recognize them or not, that make any body part weaker, less able to be repetitiously used, faster, slower, or less duration, less stamina, weakness, any body part, and or less comfortable when you use it, or even when you don't use it, chronic pain or whatever. Those are the things that need to be very, very fleshed out. They need to be proven to help you, thread the needle through the path of the grids, or if you're not getting a grid because you're under 50, to really carve, then you have to actually explicitly carve out all 12,000 jobs. And sometimes a bad trigger finger can wipe out a bunch of jobs. And no, no pun intended, Leo, when I said trigger finger. So I say this all the time, guys, and I'm saying it to someone today that's probably not here, but relying on the one thing just because it is a thing that wipes you out from all work, maybe it's excessive fatigue due to some sort of fatigue disorder, isn't necessarily going to do the job for you. If you have bad knees that prevent you from walking 8 hours a day, back that prevents you from walking 8 hours a day or standing, you got to get those things worked up. Even if you're like, that's not what stopped me from going. I don't care. The reason why I'm telling you this is because this is what you need to do to prove all the requirements in the case. It doesn't matter what you think, what you feel, and what you know about why you can't work. It doesn't matter. This is what the rules will have us do, particularly for things like fatigue, and I would say even Shep, mental health stuff, which is largely subjective, and you can't see it on an MRI. Got to really, really address the other things. Or just don't be surprised when we get denied, guys. You know, I can lead a horse to water. I can't make him drink, right? Siren says, okay, on my x-ray, it's showing why I have chronic musculoskeletal pain, and that's why I have the CE. Okay. I would prefer an MRI, but if you can get yourself an MRI, it tends to show more. Sorry, I'm getting musculoskeletal pain in my neck. Patrice is in the house. Oh, Patricia, sorry. My question is too long and you're leaving. It's a lot. You could, I'm glad you subscribed. You know, Patricia, if you want, if you prefer, you can do it under a video if you want. You can email, but honestly, this is my time. You know what I mean? Like my email is going to be checked by somebody else, and they're going to be like, "Hey, if you want a prepaid consult, here's the link. Go prepay, and we'll set you up for a consult." So it's got to kind of be here because outside of this, I am like 14 hours a day working on my cases for my clients and other aspects of my professional life. You know what I mean? So that's all I'm saying. If it's something where you want to know if we can represent you, Patricia, just go to joydisability.com and click on the free eval form in the upper left. It's just a link, and it takes 30 seconds to fill out probably. That's for representation. If it's just to talk about things, that would be a consult. So you don't really want to do that unless it's something really productive that you need to have done, and it would be worthwhile, you know, to your pocketbook. But otherwise, this is my time, you know. So again, do the free eval because then someone at least is going to look at it. They're going to see if it's a representational thing, and they're going to see if we have openings. And if we do, they're going to ship it to me, and then I make a phone call to you. Patricia says, I have a lot of physical impairment. I see the doctor every 2 months and 3 separate visits to the same doctor in between. My tests are old, but my treatment the same. Okay. I'm not sure what your question is. How I do video. Oh, Patricia, go ahead and do the eval. Hop right in there. Go to joydisability.com. Look at it. When you go right to that page, there's a little link in the upper left that says free eval. Just click on that, fill it out, and it's going to come to us. All right? And someone will get back to you. And if it could be me calling you even. And if that means that we actually have a potential opening. As some people here know, you know, we don't act like a factory. We don't just take every case that walks in the door because hey, they might win and then we get a fee. We only take the amount that is humanly possible to fully represent, and it's always been that way, and that serves us well. We're definitely not a factory type of outfit, which I know there's plenty of. So, and I'd say sometimes if you can't get anyone, maybe it's better to have that than nobody. But I'm not even sure about that because I don't know. Yeah. So Patricia, go ahead and do that. And I promise you someone will get back to you. Even if it's to say we don't have an opening. But at least you'll know. Okay? All right. Anybody else? Anybody? Anybody? Do, 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 do. Yeah, because there's so many, there's questions in the eval that give us some of the information we need that you're not putting on here. Patricia's 55. Okay. That tells us something right there. Ah, Michelle. When Stephanie first called me, I was speechless. I would say starstruck. You were not. Stop it. You didn't show it. You're so funny. Dimple says, I've heard in other videos about fatigue and mental focus issues. Do these need to be documented by a specific specialist? You know, when I have someone who's like, I mean, there are people with chronic fatigue syndrome, and it is the basic thing that prevents them from working either reliably at all. So sometimes they can't even do part-time or certainly full-time. If that is the main thing, I usually it's one of those like a lot of doctors are, I think, what do they call it, illiterate on. We used to hear that word a lot with Lyme's disease. The doctors are Lyme's illiterate. They were not well researched. It's like a lot of things today. Post-viral syndromes, I would say a lot of doctors forever and ever were illiterate on. Therefore, they would say it's in the person's head. All those all those impairments that they don't have a firm grip on because the research is not so objective. I would say fibromyalgia is one of them. There was fibromyalgia illiteracy. There still is. Not as much as there used to be, but there still is. Lyme's disease, people that have chronic Lyme's consequences. And a lot of times that is the fatigue um, and brain fog and stuff like that. And very, very hard to get a specialist. Sometimes you have to have a specialist who's across the country and hope that they do video stuff. You get your blood work here, you get it over to them, all that kind of stuff, because the people here, depending on where you are, they're just so few and far between. Sometimes it'll be a rheumatologist I see that goes out on a limb to become literate in one of those rare areas. And it behooves them to. If they want to get a bunch of clients that no one else can find a doctor for, learn that area. Um, so mental focus, which, yeah, it's not like mental illness, right? It's like the brain fog, which can be, by the way, just because we're getting older, but it counts. Um, Definitely, at the very least, you want to always be on a regular basis complaining about those things to your doctor because they're going to show up under your review of systems, which is not medical evidence per se. It's not a doctor saying it, but it's showing that you've been complaining about it at every visit. Um, and it doesn't hurt to, even if it's just once, go into a specialist and saying, I have this chronic fatigue. I can't get rid of it. My doctor doesn't know what to do about it. They might run you through a whole bunch of blood work. Sometimes that's going to be negative. If you have a diagnosis of something else that is known to cause fatigue, like let's say you've had cancer and you've been through all the cancer treatments and you've never got back your mojo, chemotherapy, sometimes radiation, um, and if you consistently keep reporting that, that is not that rare of a side effect for some people. That's a permanent side effect to some of these treatments. Not everybody. Some people bounce back just great, which is thank goodness. But for those that don't, it is more recognized now as a possible permanent side effect from the treatment that definitely did something to the mitochondria or whatever. Um, Things like that. So sometimes the fact that you pursue a specialist for a consult, kind of optically says this person has, serious thoughts about this limitation because she's going out of her way, spending this money, whatever, to get this special consult or whatever to address, what she says is really pervasive fatigue. And then, of course, in your function report, you kind of want it to be noted, you know. Um, God, we got a bunch of people hopped on now. Okay. Shep says, today my doctor scheduled my back surgery. Ooh, with 12-month recovery. Should the two diagnoses be enough? I followed your videos on every step of them. Um, Also have a broken foot. That will depend, again, on your vocational profile, which laws apply to you. I can't say anything without, enough for what? It could be enough for some people, and it depends what those, um, the back surgery, 12 months to recover to be 100%. Well, what's the recovery to be able to do light work? You know what I mean? Like recovery depends on what your definition is of recovery. It's quite a bit of stuff you're going through. I would think that would all eliminate medium level work. So depending on whether your grid age, which grid, it depends on how far low you have to prove you can't go above. You're welcome, Patricia. What is this name? Cirrus Mystica. Do I have that right, Cirrus? Does it matter the state I live in? No. I did live in Oklahoma and filed a case and moved to Oregon. It's totally fine. My people move all the time. What state do you represent? I do all 50. I even did someone in Panama last year. And I've done consult for people out of the country that live abroad on different issues that they sometimes have. They're not really the medical part. It could be like, they're not paying me because they say this, because I'm a country and this. And then I do the research and I figure it out. And sometimes I'll write them even like a little brief that they can present to their field office that says, you're wrong, field office. This is the rules. But yeah, for representation for a case, I represent all 50. And I think I was one of the first people to do that 20 something years ago. Um, yeah, it was kind of interesting at that time. Now, a lot of people do it. Rebecca says, I was approved in 2022 for brain tumor. Okay. Since then, I have had second brain surgery for a shunt and also diagnosed encephalomalacia, brain damage. Will this help my CDR? I would think so. I'm doing my CDR paperwork now. Sorry you've gone through all that. And notice what she says, guys. I was approved in 2022. She had a brain tumor. And this is an example of how you're going to get a CDR because if you've recovered from the brain tumor, acute problem, the cancer, they found you disabled because going through all of that treatment itself is disabling and the brain tumor still being there. Then if you have what is deemed to be success from that, they have to assume you've improved. Now's your opportunity to show, yes, I survived that. However, this hasn't improved, this part, symptoms or whatever. And I also have this, and this. So in this case, Rebecca's saying that she had a problem afterwards. I assume it was not necessarily, was it known that you were going to have the second brain surgery for a shunt in that meantime? Like that's a normal subsequent thing to the original brain tumor treatment, or was that something because there was a complication? So I had a second brain surgery for a shunt. Do you still have the shunt? Are there any issues with it? Does it cause any additional symptoms? Um, and now with the new diagnosis of some brain damage, I could tell more if I knew your vocational profile. That's the age, education, experience. Are you getting any new rules that apply to you that didn't apply in 2022? That would be if you did an age category change. And do you have any other medical impairments that maybe you weren't even focusing on because you could went into the brain tumor real fast and you left it out, which some people do, which I don't think is wise, but some people do it. And now you're going to want to get them in there. So that all depends on the rest of your, medical conditions, your otherwise health and all that. Shep died. Okay, so Shep, you're 52 in a few weeks, so you're 51. So you're in that very first stage of being able to avail yourself of any of the grids, the weakest of the grids, but it's still, significant. Recently did a psychiatrist intake evaluation for meds. Just wondering if you think case is good. What did you say? Let me just scroll back up. The back surgery. Yeah, so the back surgery. So you have to prove that you can't do light work. If you're 55 and you couldn't prove you couldn't do light work, but you could prove you couldn't do medium work, which is heavier work, that's all you would need to do. But you're not. You're 52. So you have to prove you can't do light work. The lifting can sometimes be hard to prove because it seems like doctors are really hesitant to say someone can't lift 20 pounds or 15 pounds, and that's what they have to say to get you down to sedentary. However, to do light work, which we're trying to prove you can't, you also have to prove that you can be on your feet generally up to 6 hours out of an 8-hour day. That's light work. If you can't, back can implicate that, and you also have the foot thing. So I think that could be really helpful. Are you pursuing the foot thing? I know you got the back thing, and it might be the thing that's taking all your focus, but you got it. I would suggest following up with the foot thing. If it would prevent you from being on your feet 6 out of 8 hours, I would be complaining about that to my doctor. I'd be seeing a podiatrist. Some of them I'll just be like, yeah, I'm going to throw you in an orthopedic shoe and call it a day. But sometimes it'll be physical therapy on the feet. Keep those worked up, Shep, and that will give you more fodder for saying, I cannot be on my feet 6 to 8 hours, which is required for a light job. I cannot do light work. If your doctor says, I don't want him lifting over 10 pounds, that will help you. If the doctor says he's very impaired, I need him to not lift heavy things, don't lift over 25, then he's screwed. Then you're screwed, because that would be akin to even more than light work. And you got to get yourself down to sedentary, which is 10 or under. So workers' comp doctors frequently use the 25 thing, and that's medium level work. I've made the argument to ALJs that you can't listen to the workers' comp restrictions because, they are designed for something completely different. They're not even saying the person can lift up to 25 occasionally throughout the day. They're just saying that is beyond that would be unsafe even once. So, like there's different definitions of what the restriction is, even given the number. Yeah, I mean, you got the use of the grids. You just got to make sure you're very focused on what part of those grids and what that means. And I'd say the foot for the walking to prevent being on your feet and standing. Could you be a cashier that doesn't have to lift a lot? No, I can't because I can't stand for 6 to 8 hours. So the feet and the back becomes very implicating there, I think. So you have to, develop your evidence in that regard. Donald is in the house. Hi, Donald. I don't think we've met. If I get a 100K, 100,000 check from insurance, if I get a $100,000 check from insurance, get a $100,000 check from insurance, being a beneficiary and on SSI, Donald, can I endorse the check and give it away to no? So you're saying, and just so you know what he's saying, guys, SSI is not Social Security. It's the SSI welfare. It's for disabled people or those over 65 who are poor and can't go out and work and self-sustain. And so it's a welfare program at the federal level. No, you can't get stuff that you could then spend to support yourself, give it away, and then stick your hand out to your neighbor. Come on, you know this. I'll give away all my wealth so that my tax-paying neighbors have to pay for my food and my shelter and all that. That wouldn't be right. If you're getting a $100,000 insurance, you use it to support yourself. Now, you could use a specializing type of professional where you want that insurance to not come to your name. You'd want someone who knows about SSI and probably Medicaid too, because you could easily lose that, my friend. And it can go into a special needs trust. You won't be able to willy-nilly take from it because you're going to be the beneficiary, not the trustee. And it has to follow certain trustee rules so that you don't have all this money that you could then support yourself because it's not under your domain. It's just designed to give to you when you need it for things that SSI does not cover. That could be it could buy you vacations. It could do a lot of things. It's a very specialized trust, special needs trust, and the person who prepares them needs to know about SSI and preferably Medicaid. They're usually definitely on the Medicaid side, but it's to make sure it jives with SSI. I did one a long time ago. I mean, in fact, it was before I even did this work full time. It was like 2002 or 2001, and it worked. It was like a settlement from a divorce, and we had to do that. But you need to do something legal and specific to prevent that from taking away your SSI, if that's your goal. And if you endorse it and give it away, would be very foolish, I think. And you will still lose your SSI if you do that because it is going to be counted against you. There's a look back period. And they're going to inquire and they're going to find out because that's how, So I wouldn't do that because it could also mean that by the time if they keep sending you SSI because it takes them a while to actually connect the dots of what you did, they can hold you responsible for an overpayment. And so when you eventually get back on SSI again, assuming you're eligible again, still disabled and now you're poor because you gave away your, 10 years from now, you get your SSI back, you might have an overpayment. And then you know. So play by the rules, please, particularly when you're, taking gifts from your neighbors. That's what I got to say about that. All right. Ton is in the house. Hey there. Hubby's case moved to step 4 on recon. Okay, again, we don't really know what that means because that's probably not the sequential evaluation step 4, so don't confuse it. That's probably an internal step 4 at the field office. In SSA account last time, I think it was immediately denied. Yeah, that's because that means the medical decision has already been made. Some say you can call SSA at this point to find a decision. Is this true? They're going to send you a letter, so I don't know why you would have to do that. Just wait a few days. If they're still in the I don't know if they're going to. Actually, I take that back. You could try because they say 15 to 30 days, but that might. Sometimes I think that's by the time they get the letter out, but they might already have it there and it's just queued up for a letter, maybe. So you could try. I mean, you can call them and the field office. I think maybe even the 1-800 number. Do you guys know that number? 800-772-1213. Yeah, but I don't know. I think they'll just wait for the letter. Versus sitting on hold if they have a wait. I don't know. They might not. I called the SSA yesterday on a case. Can't do too many of them in a day because sometimes you have to sit there. But I got through. There was maybe a 4-minute hold. That was pretty cool. Okay. Tom says, at which step will they look at the grid rules? Technically, the grid rules, there's a grid for all the age categories. I mean, even the young people. But the result is always able, able, able. So technically, for practical purposes, I would say 50 and above. There's a definitive grid rule that can be utilized. So definitely, he's in the best grid rule. Does he have an attorney that could help him determine which kind of evidence he needs to get it there? You're about to get a decision, right? That was you. I would say if he doesn't have an attorney, see what happens. He might prevail, and then this is going to be moot. If he does not, now's the time to. Then don't wait till 2 days before you have to appeal. Get someone right away. If you want us to look at it, go to that joydisability.com. Actually, you guys can see it down here too. Just look at the upper left-hand corner when you go to that page right there, it's going to be right there up in the left. And we'll take a look at it. Ton. Double R's in the house. Why initial decision so long in Texas? It's not really state related per se. It's been 12 months. Yeah, I had a recon that was 15 months. That wasn't Texas though. But yeah, I mean it could be. I think it's there probably is some state differences, but sometimes I just think it's the adjudicator and when I say state differences, I think because some states in some offices maybe they had a series of people leave and they haven't filled a spot. They're trying to save money, whatever. Someone earlier had brought up that the CDRs, I'd done a video on this. I think it came out already because I got the email like this week, I think, that they're moving CDRs out so the state adjudicators don't have to do them anymore. They can focus on initial and recons to help that speed up. So hopefully that will make things a lot better. They're taking the CDRs and they're doing them in-house in the SSA. So Portal says unassigned at step 3. Unassigned at step 3. Unassigned. Huh. I really don't know. But do you have an adjudicator? Did you get a request for a function report? Double? Did you get a request for a work history report or a function report? Did you get a letter from DDS saying, hey, we're working on your case. If you have any evidence, send it here. Did you get anything like that? If you did, look at that number and make a phone call and ask them and find out if you have an adjudicator. If you're sure you don't, from what you're saying here, it has been a long time. And I would think at that stage, you're going to want to call, you might want to reach out to Your senator or your House of Representatives rep. I always say pick the one that's coming up for election the soonest because they might be more apt to be a little more on the ball to help their constituents. If you go to their webpage, there is a link. You can find it someplace. I wish they all kind of had them in the same spot, but it's by and large always called something like help with a federal agency. And then Social Security shows up as one of the options, or you would write in if they had you write in. But usually they give a list of all the federal agencies. And that's when you tell them, hey, this has been sitting for 12 months, blah, blah, blah. They told me I don't have an adjudicator. Can you inquire? And, other people have adjudicators faster than I do, etc. Dimple says she wants to move to Tennessee, just not happening anytime soon. Hey, Juvenile's in the house. Hey, Juve. I have a friend named Juvenile. I think he's Portuguese. Oh my God, I've known him for like 30 years. We were very like-minded. It's very cool. Hi, he says I have a bad hearing problem. I think my friend does too. That's interesting. Cochlear surgery already done, and next year we'll do other cochlear surgery. We talked about this last week, right? I think I can qualify for disability, but reading all this cases that are talking to or taking too long. I'm going to continue working and forget about my application that I already submitted. Well, I mean, if you're able to work, why wouldn't you? Just because you can collect SSD, that's not, you know what I mean? Like if you can work through the cochlear, I don't know, that's kind of a blessing, right? If you weren't working, I mean, you can't even apply and still be working. If you're working full-time or SGA, they're just going to have to deny you anyway, so that's not going to work for you, you know? Rebecca, oh, I just got to scroll up. Rebecca. Okay, that was okay, yeah, 2022 you said, right? And CDR. It was not known. I had complications with my brain fluid. All right, I see what you're saying. The need for a stent was not known previously. That was just a complication. Okay. My brain fluid not flowing properly since my original brain surgery. I have left-sided weakness, coordination issues from the brain damage. I do OT and PT 4 times a week. That's my girl. Good. That's good, good, good. Because now you're proving all of these functionally limiting symptoms. Walking, sitting, standing, maybe gripping with your left, lifting. Good, good girl. I mean, good that you're getting it all addressed. Ah, Shep says he's seeing a foot doctor tomorrow. Very good. Hey, Furry's in the house. Mail is slow. Call them. That's Furry's recommendation. Jonathan, hello. I got this letter from SSI, SSDI. I met the medical onset, and they have not made a decision yet on the non-medical. Did you see my email? I did happen to bump into that. So take a look, see if you haven't checked yet. Crystalman is in the house. Hi, Crystalman. I don't think we've met. Thank you for being here. I have SSDI benefits since February. Now March. Okay. I just got a letter from Treasury stating SS benefits will be affected up to 15% because I owe back pay. Oh, all right. Well, you owe, is that back child support, unpaid child support? Well, you can kind of be glad now it's going to get paid out of your benefits. So now you can pay it. That's good, right? Donald says, everyone subscribe channel is the like button YouTube. Everyone subscribe channel. I appreciate that, Donald. Oh, well, okay. So Crystalaman's question has to do with getting a letter saying it's going to be garnished. Well, you don't have to figure out whether it's a scam or not because it's going to start coming out of your check and then you'll know it's not a scam. If it never happened, because do they tell you to call or do they not tell you to call? And does it say in that letter if you want to appeal, you can? Because maybe you don't owe that back pay. Maybe you paid it and they just don't have it recorded. Maybe your state misinform them. Um, or let's say your SSD is so low that 15% would be devastating. And that can happen to someone just trying to make basic ends meet in a non-expensive cost of living environment. Um, so it's not that you can't get it below 15%. For whatever reason, they're just giving you that somewhat low amount, low percentage. um, what I would do, Christelaman, is call your field office by looking it up online, or we used to say in the yellow pages, but not anymore. I wouldn't, just in case you're concerned about the letter, and what if it has a phishing phone number in there because it is a scam, I would call the field office and confirm. I, I hesitate because people can make letters look exactly like the real McCoy. So always call what you can otherwise find out is the field office number and call that and confirm it. And then you decide whether you want to appeal, or maybe you're like, no, I really do want to get these arrears paid off, and I can live without that 15%. I just got to cut my Netflix back to basic instead of deluxe. Just kidding, but you know what I'm saying? Like, but for everybody, I would call the number you can otherwise confirm without relying on that letter's accuracy, just in case, because scams can come from anywhere in any way. Definitely email, definitely text. So I would take the letter for what it is. It's potential information. That's probably true, but don't call the number in it. Call the number that you can get separately, and you might even see that it's the same number, which is fine. And I wonder if I even have, hold on a second. Give me a second. I'm going to post you guys a link to the Social Security Administration's field office locator. Here we go. And I use this all the time when I'm trying to find the field office for my people. If I have to, when I send my first letter and all that. I'm putting it in the chat here. All right. You see that, guys? ssa.gov/locator. That's going to get you to a page that has the address of your field office, and there's a link there that says office information. Click on that. It should give you the fax and the phone number. Now, some of these, I can't stand this. Some of these field offices refuse to put their local number on there, and they're going to direct you to the 800 number, 772-1213. Really annoying. Call the 800 number then. But when you do that, just say, can you give me the direct number to the field office, amongst other things, and then write it down forever. And feel free to share it to me. Because, sometimes you want to call your field office directly, not some nebulous in a cloud national hotline. But in the meantime, you could probably find out if that's legit through the 800 number. But if not, get the field office number from them if it's not otherwise posted at this locator, and go directly to the source and say, hey, did you guys send me I don't know what they call it, a lien on my SS, that kind of thing. Jonathan, you are very welcome. Old Grizz is in the house. Hi, Old Grizz. Thanks for taking the time to answer all these questions, Stephanie. Your help is a blessing. Oh, you are a blessing too. You are. And I think you're on my roster today. Chris Solomon says, yeah, that makes sense. Thank you, as always. You are very welcome. Thanks for coming today. We are at the 2-hour mark, guys. Any last questions? Anyone? So I banged out a bunch of finalized function reports today. And before I got on here, I think I have an 820 or an 821 to do very shortly, and then a couple other checkups, and then continue on the basics. Got a couple applications out this week for people. A couple appeals in the next couple days, but anyway, just the basic stuff, and then all the while on the cases going forward as we get the case from no brief to awesome brief for their hearing. There's so many different aspects to it, different stages. Everybody's at different stages, so it takes a little bit of, multitasking with all the different things. It's not just one thing one focuses on. Oh, thank you Furry says, have a great day, Stephanie. You too, Furry. Good to see you. Glad you're showing up. I hope you're doing okay. All right, guys. So I think we're good. 2 hours, good, 2 solid hours. If anybody needs to post a question that is easily answerable, just do it under any video you see. I will, post your post, and I will get to it. And if it's something that can be done in a video, I would love to do it in a video. And I will link the thing to you first, so you see it first, and then it'll probably go public, when the queue's down. And if it's not something that's really suitable for a video, but I could do a quick verbal dictation response, I'll do that. Sometimes it's just not even, and sometimes people are just saying hi, so then I just say hi back. But we could try to get everybody's questions addressed one way or another if we can. And of course, if it's something that's one-on-one and you need me to really research and focus and connect dots and read documents and read evidence, that would be a prepaid consult, obviously. And they're not that cheap, but they're worthwhile to some people for some reasons. Furry's got 2 grandbabies keeping me busy. I wonder if I'll ever have grandchildren. If I live old and healthy, I hope so. But I don't really want my kids to rush either, All right, guys, let's have a great week. And I appreciate you coming on. Please what did they say? Like, subscribe, and what's the other one? Share. And what else was I supposed to say? Oh, yeah, visit the 12 o'clock recordeds. Those are very helpful. They are very supportive, in particular for the 1%ers, as is the memberships. Yeah, so that's, we took one, well, in this last week, of the kinds that we don't usually have a lot of openings for. They come up sporadically, and people just can't get attorneys for them, generally speaking. They're not ones that attorneys, there's some areas that only a few of us really like to or are willing to, step into. But anyway, did that this week, and I don't think that would be possible without what goes on here. I really don't, because it really reduces the amount of pro bono hours that have to be done for those. Because there is more pay available for them that isn't going to be coming from the case. So I appreciate it, and I think those people appreciate it. So anyway, you guys all have a blessed day also. Thanks for stopping in, and I will see you next Wednesday at 1 p.m. hopefully, and if not, on all the other videos during the week. All right, take care now. Bye-bye.